Understanding contract discharge in real estate transactions. In the previous chapter, we examined the different classifications and structural types of contracts, including bilateral and unilateral agreements, express and implied contracts, and the legal implications of contract classification. Once a contract has been properly formed and classified, the next important legal concept involves understanding how contracts come to an end. The legal termination of contractual obligations is known as contract discharge. Discharge occurs when the parties are released from their contractual duties and the agreement is considered complete or no longer enforceable. In real estate transactions, contracts may be discharged for several reasons, including successful completion of the transaction, mutual agreement between the parties, or external circumstances that prevent performance. Understanding contract discharge is essential for real estate professionals because the conclusion of a contract affects the rights and obligations of the parties involved. Properly identifying when a contract has been discharged helps prevent disputes and ensures that transactions are handled according to the terms of the agreement. Contract discharge. Defined contract discharge refers to the termination of the legal obligations created by a contract. Once a contract has been discharged, the parties are no longer required to perform the duties outlined in the agreement. Discharge can occur through several legal mechanisms, including completion of performance, mutual agreement, cancellation, rescission, impossibility of performance, or breach. Each of these mechanisms provides a legal pathway for ending the contractual relationship between the parties. In real estate transactions, discharge most commonly occurs when the contract is fully performed at closing, meaning the buyer has paid the purchase price and the seller has transferred ownership of the property. Once the deed is recorded and the transaction is complete, the contractual obligations have been satisfied and the contract is considered discharged. Completion of contract performance. The most straightforward method of contract discharge is full performance. Full performance occurs when all parties involved in the contract fulfill the obligations they agreed to perform. In a typical real estate transaction, the buyer agrees to provide the purchase funds while the seller agrees to transfer ownership of the property. During the escrow process, both parties work towards satisfying the conditions of the contract, such as completing inspections, obtaining financing, and delivering required disclosures. When the closing occurs and the transaction is finalized, both parties have fulfilled their obligations. The buyer receives ownership of the property and the seller receives the purchase funds. At that point, the contract is considered executed and discharged. Full performance represents the ideal outcome of a contract because it reflects successful completion of the agreement without disputes or complications. Mutual agreement to terminate contracts may also be discharged through mutual agreement between the parties. In this situation, both parties voluntarily agree to cancel or terminate the contract before performance is completed. This type of discharge often occurs when circumstances change and the parties decide that continuing with the transaction is no longer in their best interest. For example, a buyer and seller may agree to terminate a purchase contract after the inspection reveals unexpected property issues that both parties prefer not to address. When contracts are terminated by mutual agreement, the parties typically document the termination through a written cancellation agreement or contract amendment. Proper documentation helps ensure that both parties clearly understand that the contractual obligations have been released. Mutual termination demonstrates how contracts can be flexible when both parties agree that continuing with the agreement is no longer practical. External circumstances affecting performance. In some situations, external circumstances may prevent the parties from completing their contractual obligations. When these circumstances make performance impossible or impractical, the contract may be discharged through legal doctrines such as impossibility of performance or frustration of purpose. Impossibility of performance occurs when an unforeseen event makes it impossible for a party to fulfill the obligations of the contract. For example, if a property is destroyed by a natural disaster before closing occurs, the seller may no longer be able to transfer the property as originally agreed. In such cases, the contract may be discharged because the subject matter of the agreement no longer exists. Frustration of purpose occurs when an unexpected event undermines the fundamental purpose of the contract. For example, if a buyer purchases property for a specific commercial use that later becomes legally prohibited due to zoning changes, the purpose of the contract may be frustrated. Courts examine these situations carefully because not every unexpected event qualifies as a legal justification for contract discharge. The event must be significant enough to fundamentally alter the ability of the parties to perform their obligations. Online discussion. 1. Question. What is meant by the term contract discharge in real estate transactions? Answer. Contract discharge refers to the termination of the legal obligations created by a contract. Once a contract is discharged, the parties are no longer required to perform the duties outlined in the agreement. 2. Question: why is full performance considered the most straightforward method of contract discharge? Answer: full performance occurs when both parties complete the obligations described in the contract. Because the agreement is fulfilled as originally intended, the contract naturally ends without disputes or legal complications. 3. Question: how can external events lead to contract discharge? Answer: external events such as natural disasters or legal changes may make it impossible or impractical for the parties to fulfill their obligations. When performance becomes impossible or the purpose of the contract is frustrated, the law may allow the contract to be discharged.